There are 5 elements, 5 things that have to happen for liability for a misrepresentation to occur. And I promised Keith that I'm going to try to avoid legal jargon as best as possible, and he's going to stop me if I get used too much legal jargon. Essentially, you're looking at the perfect storm. The 5 things that have to occur is, number 1, there has to be a special relationship between the parties, and I'll get into each of these elements in a little bit more detail. But right now I'm just listing them. 2, there has to be an untrue, inaccurate, or misleading representation. 3, your representative has to act either intentionally or negligently when making the misrepresentation. 4, the candidate has to reasonably rely on the misrepresentation. And finally, the candidate has to suffer damages as a result. So let's start with the special relationship. In law, it's referred to as the duty of care. And the test that is applied is it reasonable, reasonably foreseeable, the test is the reasonable, foreseeable, reasonable reliance test. Is it reasonable and foreseeable that the candidate's going to rely on the misrepresentation? So after struggling through all that, I can tell you that employers are almost always going to owe a duty of care. There's always going to be a special relationship found with prospective employees, and I think that applies to almost every aspect of the pre-employment relationship. So if you have a website that refers to opportunities with your organization, if you have a booth at a trade fair, if you are advertising a position, I think in all of those cases it's reasonably foreseeable that a person's going to rely on that information. So element 1 is almost always going to be satisfied. Element 2, there has to be an untrue, inaccurate, or misleading misrepresentation, and that includes failing to provide highly pertinent information. So technically there's no misrepresentation there, but by leaving out very important information, they can constitute a misrepresentation. The picture below actually is well placed. One of the situations where misrepresentations have been found and litigated are when an employer misrepresents the financial health of the organization, telling a candidate or implying to a candidate that, look, things are on the way up here, when in fact the opposite is the truth, and the candidate leaves secure employment to find out that his new employer is in a poor financial position, which could affect his job security. Standard of care, I'll go right to the bottom, is the reasonableness standard. The person in your organization who is dealing with the candidate must take reasonable care to ensure that the representations being made are accurate, not misleading. So that doesn't mean everything you say, you have to guarantee everything you say. It doesn't mean you have to fully disclose every bit of information, but it's higher than acting honestly. Taking us back to the financial health of the organization, a representation is made in a job interview that, hey, we're fine, we're on our way up here, we've been solid for years. And the representative of your organization may say that honestly, but still be liable if in an examination, when they're asked for the basis of those statements, the person may say, well, I've worked here for 10 years. I just thought we were sound, and even though the statement was made honestly, the employer representative really didn't do any. There was no basis. They didn't do any digging before making that representation to a candidate. If that makes sense. And Keith has promised to smack me if I stop making sense. The last two elements are a reasonable reliance and damages. So the representation or misrepresentation doesn't need to be the only factor that induces an employee to, for example, leave his job and move to, say, Ottawa to join your company. It just has to be one of the factors. You can have a situation where the person is looking for new opportunities, wants to come live in lovely Ottawa, but one of the factors relied upon when making the decision was the misrepresentation. That would be sufficient enough to fulfill that element. So, assuming the first four elements, I believe, are satisfied, and then the employee suffers damages. The purpose of damages in a negligent misrepresentation case is very different from a wrongful dismissal case. In wrongful dismissal cases, the damages are finite. You have a contract. You know, the contract probably requires that you provide, for example, 12 months notice. You only give 6, so you're fighting over, you know, the balance. Where in a negligent misrepresentation case, the purpose of the damages is to place the candidate in the position he or she would have been in had the misrepresentation not occurred. Now, in extreme cases, this could be a significant amount of money. Let's just look at a situation where a candidate is living in Vancouver, gainfully employed, and for some reason candidate accepts a position that pays him or her $30,000 less, but the candidate believes that this is a good opportunity. Candidate moves his or her family to the Ottawa area, takes up employment, works for about a year and a half, or say a year, so $30,000 loss of income right there, and then there's a breakdown in the relationship, and he or she discovers that there was a misrepresentation, and then they're unemployed for another 2 years, moving back to the West Coast and finding work. Well, in that case, you're looking at the loss of income, the delta between what they were earning and with their previous job and what they earned with your organization. So say a year, there's $30,000 there. The loss of the income for the 2-year period of unemployment, which would be based on the income they were earning at their previous job. You've got general damages for the stress and inconvenience that were caused, and other costs like relocation costs. So that is what you're looking at in a misrep situation. So for some examples, the seminal decision is the Supreme Court of Canada's decision in Queen and Cognos. I always look at this case and think it involves the government with the Queen, but it was a gentleman named Doug Queen who was working in Calgary, gainfully employed with his family and children. Cognos advertised for an accountant to help develop an accounting software, and Mr. Queen applied. He was interested in a new opportunity. During the interview, Cognos said that the project would be a major one. It would be developed over 2 years, and it would extend beyond the 2-year period, and they expected that his staff would double. Cognos did mention the fact that the project had yet to be, funding had yet to be approved, and the position was actually subject to budgetary approval. So Cognos makes the offer. Mr. Queen accepts. He moves his family to Ottawa, leaves his job, works for about a year and a half before losing his job with Cognos because the funding for the project had been cut. He had an employment contract with Cognos that limited him to approximately a month's pay. So what he did was he framed his case in negligent misrepresentation, and the court agreed with him, and he was awarded, this is back in, I guess, it was 93 ultimately, but really everything took place in the 80s. He was awarded about $67,000 in damages, which included about $50,000 in lost income and about $12,000 in losses that arose out of the purchase and sale of his home in Ottawa. Other examples are a Canadian firm was recruiting a British ship captain They were found to be aware of a change in the Canadian laws that affected this gentleman's ability to get certified to, what do you, I guess I can't say drive ships. What do ship captains do? Anyway.
The captain.
The captain ships, that's right. Okay, affected his ability to captain a ship in Canada. The employer didn't reveal this in the interview. I suspect that someone in the employer organization knew about it, but the person running the interview didn't know about it. I can't imagine the employer intentionally withholding that information. So the captain moves to Canada, finds out about these new laws, and cannot work as a result, sues the employer for negligent misrepresentation. And in that case, the court found, yes, employer, you're liable for the damages, but the ship captain was also liable for approximately half the damages as well, for really not doing any diligence on his part to look into whether he can captain a ship in Canada. The second example, I've mentioned that already. And third example involves a representation about when a position would open up. And the representation was made based on the employer's previous experience. So in that case, the court found that even though there was a representation that was not exactly true, it wasn't negligently made because there was a reasonable basis for the representation. So those are some examples. Actually, I was watching, I don't know if anybody, hands up there in the studio audience if you've seen the movie Ides of March, and if you actually put up your hand, I would like to know that. Have you seen the movie Ides of March?
I have.
Yeah, I think the story, if you haven't seen the movie, a central part of the story actually involves what I believe to be a negligent or maybe a fraudulent misrepresentation, where one of the leading characters is an assistant campaign manager for a gentleman who is running for president, and his competitor, who is running the campaign for one of the other candidates, sets up a meeting with him and basically represents that he's willing to hire him. And it's subsequently revealed that the whole purpose of that was that they expected this leading character to tell his employer that he had received an offer of employment from the competitor, knowing that his employer would fire him and it would sort of cause all kinds of problems in the campaign. So anyway, if you've seen the movie, I would think that would be a negligent, if not fraudulent, misrepresentation.
And for those of you who've rented the movie, you can send the bill to JP for having ruined it.
Yeah, that's true. One other example is a situation that came across my desk not too long ago that you probably want to think about as well. Is would liability for a misrepresentation, I'm trying to get my wording right, can a candidate's spouse sue an employer for damages that are caused by misrepresentation? In the case that I had, or I didn't have, but I just reviewed it briefly, counseled someone, was a husband working for a large organization agrees to accept a transfer abroad, and they are given a date for the transfer and led to believe that the transfer was going to happen. It was a done deal. The employer forgot to tell the husband that there were some immigration laws in the country that they were going to that had to be satisfied, and if they weren't satisfied, they wouldn't be able to transfer the husband to the workplace abroad. So what happened was they couldn't satisfy the requirements, they couldn't transfer the husband. The husband continued to work for the employer in Canada, so the husband didn't suffer any damages. The problem was that the husband's wife was a professional, gainfully employed in Ottawa. She gave notice to her firm that she was going to be leaving and joining her husband abroad in his new posting, so she had essentially lost her job as a result of the misrepresentation, and was employed for some time as a result. So my opinion was that the duty of care would be owed to not only the employee but his spouse. It's reasonably foreseeable that the spouse is going to be moving with her husband, and the spouse is going to be relying on the representations you're making with respect to the transfer. How am I doing for time here? I will move it along. Okay. Protection from liability. This is, I guess, the important part. What steps can you take to make sure that you're protecting your organization from liability as a result of a negligent misrepresentation? Well, first of all, the standard of care. That's the one thing that certainly you can control. Be honest with the candidate, but as I've stated, honesty is not enough. So don't guess. If you're asked a question and you don't know the answer to it, then ask the candidate if this is important, and if it is, take some steps to get them an accurate answer. Also, be aware of pertinent information. You want to think about the candidate's position in life and concerns that the candidate may have. Make sure you disclose all pertinent information accurately, and listen carefully to the candidate's question, because he or she may be telling you that certain things are important to him or her. Secondly, if an offer is made and accepted, you want to have in the employment contract an entire agreement clause. These clauses typically say something like, the employment contract constitutes the entire agreement between the parties. It supersedes all agreements and negotiations. There are no representations that were relied upon that don't form part of the agreement. So essentially, you're contracting out of a lawsuit for negligent misrepresentation. Okay, I will speed this along a little bit here. Liability. So this is a situation in a wrongful dismissal. You've recruited the candidate. They've worked with you for some time. Things go poorly, and you will now want to dismiss the candidate. Your typical damages in a wrongful dismissal case involve an obligation to give an employee notice or pay in lieu of notice. You're notifying the employee that I'm sorry it's not working out. We're going to terminate your employment, say, in 6 months' time. Or at your option, you can have the employee leave immediately, and you pay the employee 6 months of total compensation, subject, of course, to some exceptions, just cause being one of them. I won't get into that right now. So when you have, I'm missing a slide here. When you have an inducement, I'm going to go back. You have an inducement. You say you've recruited someone and convinced them to leave a job that they were at for 15 years, and they work for you for 2 years. Well, typically, 2 years is not going to require a lot of notice. But if an inducement or recruitment is found, a court could find that essentially you've got an employee with 17 years service on your hands, and you have to give them sufficient notice to terminate a 17-year employment relationship, which is, can be anywhere from 12 to 20 months, depending on the circumstances. So you're essentially stepping into the shoes or assuming the service that the employee had with his previous employer. Other damages that it can include are moving expenses. Certainly, if you pay for an employee's expenses to move to Ottawa, you're likely going to have to pay a similar amount to move him or her back to their original city if it's reasonable for them to move back. Real estate losses, carrying costs on a property, commissions, etc., can also be recovered. Okay, finally, I'm not an immigration lawyer, and I'm not certainly not going to represent myself to be one, but if you're involved in recruiting a foreign worker, you also owe a duty of care to the Canadian government to make sure that you're accurately conveying the qualifications of the worker and the type of employment being offered. And there's some serious consequences there if you were found to have misrepresented the foreign worker's qualifications or the employment involved to essentially get a visa allowing the person to work in Canada.